everyone, and welcome to the India Story, where this week our focus is really going to be on Parliament because a lot has been happening in Parliament. First of all, there was that entire incident where people got inside, breaching the multi-layered security that is supposed to exist in Parliament. Somehow, they were able to breach that and set off, smoke canisters inside Parliament. Now, obviously, it has led to a prolonged ruckus inside Parliament and outside. They've been arrested, the conspirators have been arrested, but there are questions. How were they able to get in the first place? And what does that say about security and how security can be tightened? Also, it has led to some disruption in Parliament. But in the middle of all of this, there are some pretty major bills that are also being tabled and perhaps discussed and who knows, passed. Notably, and that's something else that we're going to focus on this episode of the India Story, the new criminal law bills, the Sanhitas as they were called. They'd been tabled earlier. They were then withdrawn with the recommendations of the Standing Committee. Then they were reintroduced after those recommendations were actually introduced. So what are these new Sanhitas going to be saying? Does that help in solving what is perhaps the biggest single problem or impediment in the India story, which is judicial delays and the slow process of the judicial system? Will these help in unclogging that? We're going to get a range of experts to talk to us about that, from somebody who's a member of the Standing Committee of Home Affairs who looked at many of those recommendations and made some suggestions. Sujit Kumar is going to be with us on that. But in addition, we're going to be joined by Pinky Anand, senior advocate, a former Additional Solicitor General of India, and by Dr. Madhavan, who's the president of PRS Legislative Research, which have been doing a lot of inputs and research and analysis on what should be there on those criminal bills. Something else major that happened this week was the Supreme Court verdict on Article 370. The Supreme Court essentially upholding the abrogation of Article 370, saying that the manner it happened was correct. Also saying that Jammu and Kashmir had no internal sovereignty after signing the Instrument of Accession, and that Article 370 was only a temporary provision. Now, of course, we know what all has happened internally, and that matter has gone through. But it's interesting to see what the international reaction has been. And the interesting part is not too much international reaction, quite frankly, to what the Supreme Court has said, other than some statements from the usual suspects, Pakistan and China. So we are going to be joined by Sir Raja Mohan, talking us through that international repercussions of this and pretty much answering the question of whether the fact that Jammu and Kashmir is an integral part of India is now something that is globally accepted. So all of that coming up on this program, but let's start by taking a look at the major headlines you should be tracking this week.
The India Bloc, an alliance of opposition parties, will meet on December 19th to discuss their core agenda, seat sharing and joint campaign strategy. It will be the first meeting of the alliance after Congress' defeat in the recently held assembly polls in Rajasthan, Madhya Pradesh and Chhattisgarh. It is expected that the regional parties would now demand a greater say and share in the alliance. India voted in favor of a draft resolution in the UN General Assembly that demanded an immediate humanitarian ceasefire in the Israel-Hamas conflict, as well as the unconditional release of all hostages. The 193-member UN General Assembly adopted the draft resolution introduced by Egypt at an emergency special session. The resolution, however, made no mention of Hamas. In October, India had abstained in the General Assembly on a resolution that had called for an immediate humanitarian truce. In a major setback to electronic manufacturing giant Tesla's ambitions to enter the Indian market, the government has said that there are no intentions to offer subsidies for the import of electric vehicles into the country. This was clarified by the Minister of State for Industry in the Parliament on 14th of December this year. This essentially means that talks between India and Tesla have once again hit a roadblock. While the government has been pushing for Tesla to manufacture cars locally, the automaker is insisting on lower import taxes initially to make its globally produced vehicles competitive in the Indian market.
And let's now spend a little more time on that breach of security in Parliament Parliament attack, as it was being called, and that also at a time when the memories of what happened so many years back very fresh in everyone's mind. Lots of questions unanswered. How were they able to get in? How were they able to breach what was said to be impregnable security in Parliament, the new Parliament building with so many layers of security put into it? What was in those canisters? What if it had been something more dangerous than that? Lots and lots of questions. And those questions, of course, have led to other aspects, including the holding up of Parliament and a question of how Parliament will continue to function in the winter session of Parliament. So here's a special report on everything that happened in that breach of security in Parliament.
A major security breach on 13th of December stunned Indian Parliament when two intruders threw smoke canisters to disrupt proceedings of the Lok Sabha. Visuals captured live showed a man wearing a dark blue shirt leaping across desks to evade capture, while the second was in the visitors' gallery spraying smoke. Members present inside the house told reporters that they were chanting slogans. Both were overpowered by MPs and security staff. Citing a huge security breach, during 0 hour in the Parliament, the two men, including two other protesters outside the Parliament with similar gas canisters, were immediately detained. One of the intruders carried a visitor's pass that was issued from the office of BJP MP Pratap Simha, a lawmaker from Mysore. Later, the Lok Sabha Speaker called a meeting with the floor leaders from different political parties over the incident. The opposition leaders have slammed the ruling government for what they called a serious security breach in the newly inaugurated Parliament. The Delhi police has registered a case under sections of the Unlawful Activities Prevention Act against 5 accused: Manoranjan D, Sagar Sharma, Neelam Verma, Amol Shinde and Lalit Mohan Jha. Security agencies so far have not found their connections with any terror group, while the government ordered a thorough probe into the Parliament security breach incident. The Lok Sabha Secretariat has suspended 8 personnel for security lapses.
Now, of course, with disruptions in Parliament, the first thing that really gets affected and held up are discussions on some of the critically important bills that are actually there for passing in Parliament. And this time, I have to say that there are 3 bills out there which are critically important for the country. And those are the new Sanhitas, the criminal bills, the bills that are designed to replace the IPC, the Evidence Act. How will the criminal justice system work? Those bills had been tabled earlier. Then they went to the standing committee. The standing committee made some changes. And after that, the bills have been reintroduced. Now, are we going to see a lot of debate and discussion and how those bills should actually be operational? Should further amendments come in at some point? How can we get the criminal justice system to work in a faster and a speedier and a more efficient manner? But frankly, we don't know, because there are going to be disruptions, and that entire question is going to be a little bit up in the air. But what should those bills actually contain? But who better to talk to? Sujit Kumar, who's an MP, who's a member on that standing committee on Home Affairs, which has actually been making suggestions about the criminal laws and the new bills that have actually been, or the new Sanhitas that have been put back into Parliament. But Sujitji, thank you so much for joining us. But before I ask you about the bills themselves and what criminal law does, the incident that happened in Parliament, I just wanted to get the sense of from you, and how have parliamentarians reacted to that breach in security that we've just seen in Parliament?
Vikramji, it's extremely concerning. Members cutting across party lines have expressed their deep concerns It's a serious breach. We are often told that there is a 7-layer security in the parliament premise. But what happened on the 13th of December is a grim reminder of the fact that no, the security arrangements were not foolproof, and there should be a thorough investigation, thorough review of the security arrangement. And I hope that such an incident is not repeated. We shudder to think, had there been cyanide or some of the poisonous gas in that gas canister, imagine what would have been the consequence, or if there were RDX in the gas canister. So this is very, very concerning, Vikramji. Hope good sense prevails. But as I see, it could be a blessing in disguise. This could lead to thorough revamp of our security apparatus.
And of course, the fact that this happened at all, because you're right, there's supposed to be really intense security, and how they got the pass, how they were able to come inside, how they smuggled in canisters in their shoes. You're right, it could happen again.
Yeah, this is why I don't want to make it political, but I really hope that the government takes extreme, which I think they have taken extreme note of it. And as I said, there could be a silver lining to this. This could lead to a complete revamp of the entire security arrangement, not only the parliament, but in every sensitive installation in the country.
All right. Let me turn my attention now to the new Sanhita. So the fact that the criminal laws needed to be changed, they go back hundreds of years, is something which was very clear cut. What were the standing committee's main views on these new Sanhitas, and were there any other changes that you think may still come via amendments or other such systems?
So Vikramji, there were a couple of key objectives behind these three new bills. As you rightly pointed out, the original bills dates back to 100, if not more, 150 years. IPC 1860, Evidence Act 1872, CRPC originally was 1861, then had a revamp in 1973. So most of the provisions in these bills were of the colonial era, and they were not in tune with our modern legal framework. So there was a need to overhaul the entire criminal justice system, particularly in the context of the technological advancements, in the context of the reality of the congestion of Indian courts. Today we have over 60,000 cases pending in the Supreme Court, over 4.5 crore cases pending in our trial courts. So these are humongous numbers. And also the fact that Supreme Court and many law commissions and other commissions have time and again pointed out that our criminal justice could be reformative rather than being punitive. So these were the key objectives behind bringing these three criminal law reforms.
But one of the questions, I guess, which I'm sure the standing committee also looked at is, as you correctly said, if you look at the real problem in the Indian criminal justice system, it is pendency, of course, a large number of cases, but above all, delays. The fact that you can have it could be, you could be investigating a crime for decades before a FIR is filed or a charge sheet is filed. Trials last for decades altogether. People languish in jails as under trials for years before they are suddenly proved to be innocent. That crucial problem of delay, it's probably the single most important reform measure that India has to still deal with. How will these new bills and the amendments help in that?
I think you have hit the nail on the head, Vikramji. I have been a strong advocate of completely reforming our judicial system and our criminal justice system. I do not claim that these new bills have taken care of all of this with regards to pendency of cases and clogging of our courts, but some efforts have been made. I can give you a couple of examples. Now, previously, there was no time limit as to when a magistrate could pronounce the judgment after the hearing is over. Today, the magistrate is, as per the new law, mandated to pronounce the judgment within 30 days after the hearing is over. Previously, the time limit for the framing of charge was not there after the issue was taken up by the court. Today, it's 60 days. Previously, there was no limit as to how many adjournments the lawyers could take. Of course, it was the discretion of the court, but easily, I'm a lawyer myself, and easily the court granted 4 or 5 adjournments to every lawyer. I guess there is some improvement in this aspect, but certainly more needs to be done.
So just looking at the things that could, for example, be done. I know that industry, for example, has been pushing for a long time to say you should have things like a statute of limitations. You can't keep things going forever. There has to be a time limit, 5 years, 7 years, 10 years, after which you say you've not been able to take cognizance of the case. The case should be dropped. This should be applied to all matters also. Surely all IOs can be encouraged to look at, their cases that are piled up, or the courts. If something is 30 years old or 25 years old, or in some cases, God forbid, 40 years old, should just be done away with so we can focus on important cases.
Well, Vikramji, while we are discussing this, I must also add that yesterday, the day before yesterday, Rajya Sabha passed the repealing and amending bill 2023. This is in addition to the Jan Vishwas bill, which was passed during the monsoon session of the parliament, and I was also part of the joint parliamentary committee, GPC, which looked into the Jan Vishwas bill. Both of these bills are extremely commendable in the sense that they have done away with many obsolete and outstanding laws that remain in our statute books. I mean, there were many laws, many legislations which were actually funny, which were actually amusing. And thanks to this government, if there is one thing which I would like to compliment this government for, it is the fact that they have really taken the effort, or made the effort to remove some of these very archaic, obsolete old bills.
A lot of what is there in the Sanitas is forward-looking. But do you think whether it's the Jan Vishwas bill or the new Sanitas, that should some of it be backward-looking also, so that those old cases, the pendency of cases, can be reduced to some extent?
Well, one of the aspects of our justice system is that any law can only apply prospectively. It cannot apply retrospectively. So for all the pending cases, these bills, I'm afraid, will not apply even when they come into effect. But I think the fact that technology has been given a lot of prominence, usage of technology in dispensing justice has been given prime importance under these new bills. I think that will really help us to reduce dependency. Technology has penetrated pretty much every aspect of human life except for the legal fraternity. It's the last frontier. So to that extent, I think these bills are really forward-looking.
There's some concern about some of the bills that are still there. UAPA, for example, PMLA, some of these bills which have got very harsh provisions, right, which are capable of being misused. A lot of human rights and other activists have expressed concern about that. Do you share that concern? And how do you make sure that there are laws that are stringent enough to take care of things like terrorism or sedition? For example, in the terror definition now, economic security has also been added. Now, there'll always be concern that can it be possibly misused? Somebody doing, you're not paying your taxes. Is that attacking the economic security of India? So suddenly a terror clause is put into some FIR or charge sheet somewhere. How do you prevent that abuse?
Well, certainly any law could be misused for that matter. Why only the three bills or PMLA or UPA? I actually welcome the fact that terrorism has been included in the BNS because there was no definition of terrorism in the IPC. But the first version of BNS had terrorism defined very vaguely. So the committee had given its recommendation that this is an extremely wide and vague definition. This should be made very specific, which the second version that was introduced in Lok Sabha 2-3 days ago has taken care of. Now, why I say I welcome this, because you had state-specific laws. For instance, Maharashtra had the Mokaka Act. You had the UP Act, the Gunda Act, and but you didn't have a central act to take care of terrorism or organized crime. Now you had instances where criminals could commit offense in the state with a state-specific act, and then move to a state which doesn't have similar legislation. So it was extremely difficult for the law enforcement agencies to handle such cases. So this is why there was a need for a central act.
Okay, I'm going to now get into the subject in slightly more detail, and there's a reason for this. You've heard from us on the India story. So many reforms have been done, so many positive things have been done, but fixing the judicial system to some extent, speeding it up, reducing pendency, perhaps the single most important item on the reform agenda. And that's why on the India story, we're going to keep coming back to this theme. Two really special experts now joining us to shed light on what has happened this week and what perhaps still can be done next phase. It's an ongoing process. Mr. M.R. Madhavan joining us, president of PRS, doing a lot of work on all legislation and how it pans out. Pinky Anand, of course, senior advocate, former Solicitor General of India. So thank you both so much for being with us to shed some light on it. Mr. Madhavan, why don't I start with you? When you take a look at the Sanhitas as have been, again reintroduced, and presumably if the din quietens down, may well be passed fairly soon. So we're going to have a completely new set of criminal laws in this country now, which is interesting because all of us have been complaining for 20 years that existing criminal laws are bad. So the new laws, better, worse than the old ones, and still changes that need to be made?
Yes, in a way, to the changes be made for the simple reason that we are saying there's a complete new set of laws. But if you look at them, and for good reason, 90% of it is the same across the three. Some of which ought to not change too much. For example, the Evidence Act is by and large, the only changes were for the electronic evidence and how to handle that. And most of it has been working well. So that's fine. But I would say, especially in terms of the new IPC, which is the BNS, a number of things are still using the same philosophy which was in the 1860 Act, which had a particular way of looking at criminal law, which I would say is more a retributive or a penal law rather than a reformative law, and which included a number of things which today you will say are civil cases. But just to give you a quick context, which when I was doing research, I found it interesting, that the British made the law, and England itself, they had death sentence for pickpocketing until 1808. They had death sentence for theft until 1832. So it's in that context that those laws were made. They're not 21st century norms. And of course, we have changed a number of them, but it still remains primarily punitive, though they have included the concept of community service without defining or explaining what that is.
All right. Pinky, that point about making it more reformative rather than punitive, don't put everything which could be civil into criminal, is obviously of direct relevance because there's this other statistic. I'm going to put it up on the screen right now. That just a sheer number of people who are actually crowding Indian jails, right? And 90%, 80% in some cases are under trials. Our jails are packed with people who don't necessarily need to be there. Some of those could have been civil matters. Some of those are cases which may not be really requiring jailing. And then you have the question of jail not paid. What do you make when you look at these new bills in that context?
That's an interesting phenomenon. And what Mr. Madhavan just spoke about reformation and retribution as two theories. I mean, criminal law has that theory across board. And also your statement about, the jails being crowded and the kind of number of cases. But ultimately, let's understand what criminal law is about. So criminal law in principle, in jurisprudentially, is meant to be something which sets down a standard for people to follow. And on failure to do so, action is taken. And increasingly, in fact, I'll support what Mr. Madhavan is saying to some extent. For example, in Companies Act, a number of provisions of penal provisions which were made for jail were ultimately amended on to being punitive, as in monetary punitive nature. But reformation is a good theory, principally, and something which should be followed. But at the same time, what we do need to act, and in particular, if you see some of the kind of offenses, let's say terrorism. I'm just taking that as a starter. Now you have economic offenses, you have terrorism. You do have to deal with them with a stern hand. And unfortunately, until you set down that standard, it doesn't seem to work. So the principle is not that you reach towards penalty or retribution only. The idea is to lay down the standard, whoever violates it, what action. I'll give you an example. For example, of cars, speeding, challans, as simple as that. I mean, until you put down a fine which is somewhat prohibitive, at least. I mean, even now, frankly, it isn't prohibitive. But it has gone up to a larger extent. I was party to those. The toll tax violation. You don't do that, people are not likely to follow. Unfortunately, we seem to still follow a principle that we have to be made to follow the law, not that because there is a law, we will follow it.
So, Mr. Madhavan, changes that you might, I mean, presumably this is an ongoing process, right? I mean, the standing committee, as you were just hearing, has come and made some suggestions and these new bills are out there. Presumably it's going to be an ongoing process. What would you do, therefore? As Pinky very correctly said, sometimes you need a danda, because if you don't have a danda, people are not going to follow the law, right? So how do you match the necessity to have a danda, which makes people follow the laws, with some of those other things? Don't overcrowd jails, principles of liberty, bail, not jail, other sort of things. So those are the liberty aspects of this entire question as compared to make people behave aspect of it. What changes would you still make, if any?
Some of the things which have been brought in, I'll just give you one example. So there was an amendment about, I think, 2006 or so, which said that if anyone has, in under trial, has served half the sentence, maximum sentence for that, would get bail. I mean, more or less like a default bail, though the public prosecutor could object, etc. Now they've added a proviso to that. They've done two things. One, they have said that if it's a first-time offender, then 1/3, not half, you can let that person shall get. But they have added that if the person is charged under more than one offense, then this is not available. Now, we all know that everyone is, I mean, for anything you do significant, the charge sheet does mention more than one thing. So which effectively reduces the chance of people getting bail. So why are we not actually making it easier? And of course, we are not talking about, I would say terrorism is an extreme case. I mean, we can't be thinking of criminal law.
Although having said that, part of the problem with laws like UAPA and others is that the charge of terrorism, that's the charge creep that people talk about. You put terrorism into every second FIR. I mean, not every second, but you use terrorism sometimes when it is not really warranted to have terrorism. Same is true with the charges that are put into the charge sheet. Sometimes excessive charges are put in to deny bail and to keep people in prison when that is not really warranted. And you must be experiencing this also. Mr. Madhavan?
Yeah, so frankly, I don't practice law, so I'm talking more in conceptual terms.
Yeah.
So if your attempt is to say, by saying somebody will get bail if they have served half the maximum sentence, then why do you have a proviso which essentially negates the main item, which means that people will not actually get, because it's almost certain that in most cases they'll be under more than one. So either you say they won't get.
Okay.
Or you say
Let me
they
ask.
will get.
Fine, fair enough. Actually, let me throw that point to Pinky, because as additional solicitor general not that long ago, it was her job to actually send people to prison and make sure they stay there for a while. Pinky, the entire concept of bail, not jail, this is obvious. I've been hearing this debate ever since I started my journalism career 30 years now. Bail, do we need a separate bail law? Do you need to have some of the provisions that Mr. Madhavan was talking about to make it, easier for first-time offenders and others? And how do you prevent the problem of charge sheet creep, where people are being charged with UAPA where maybe it doesn't really warrant a terrorism, charge in there, or that when the FIR you suddenly put 10 charges of whom 2 may be warranted, but the other 8 are just there to make sure that the person doesn't get bail?
See, I wish there was an absolutely easy solution, but let me try to just handle this from a couple of levels. So as a practicing lawyer and having seen a few of these things, I do think that the current amendments that are proposed, or rather the current provisions in the bill, which provide for bail on having a certain amount of trial time there or under trial time, is still very significant. You may have multiple charges, but you do get the benefit. And frankly, we can't always negate charges by saying they are excessive charges. If a person has committed a crime which comes under 5 offenses, so be it. But you are providing for the higher, and this is very typical. In fact, there is also a question of concurrent sentences and all, which we have simplified in the current provisions to allow people to get released. The whole idea being that don't put people behind bars forever, so therefore simplify that process. As far as the charges and all are concerned, and I do think we need another provision. See, while you were talking, there are certain acts which are, of course, non-bailable. The provisions are non-bailable. So invariably, they come in and people tend to use them. Unfortunately for us, again, systematically, people who want to violate the law utilize the provisions of law, and therefore sometimes provisions are put in or allegations are made ultimately under an act which is non-bailable. So I think there the role of courts has to come in.
Look, we know what the problem is, and it's one of the biggest issues in India. The fact that the judicial process is as protracted as it is, 5 years, 10 years, 20 years, it's like this is really going to be a bottleneck if India is going to become one of the fastest growing economies in the world, third largest economy. You can't have the judicial system working like this. So are there legal changes that you would make? So one is to say, okay, the court should work faster and have more judges and the rest of it. But when it comes to the laws, could something be done in the laws themselves to make them more amenable to speedier justice?
So I would actually again come back to it. We should have clarity firstly on deciding what can be civil cases with even monetary penalties and what can be criminal. So that takes away a lot of your case load, where the civil cases pretend to be criminal and come into the system. That's one. Second is there is this confusion about who can, not confusion in the terms of the law is clear about it. I think conceptual confusion on compounding. So there is a number of offenses where, let's say, I am the victim, I have the right to compound. For example, cheating. If I have made a complaint on cheating, I'm the victim, I can compound. Now, if I go back to say that, when do we say it's a criminal? Criminal offenses when it's against society at large, public at large. Okay, it's not against a single person, it's not a personal grouse. Okay, and that's why this public system takes over and the public prosecutor comes into the picture. Now, if as a private individual, I have the power to say maaf kar do, then should it be considered as, should I be given the power to actually say on if it's an offense against society to actually say chodo?
Last thought on that and speeding it. So in addition to changing the laws, I wonder if there can be laws or actually principles laid down for how the courts actually are operating. This concept of adjournments, tariq pe tariq, stretching things on for years. Because let's face it, the delays and a delayed justice is the actual opposite of what justice should happen. Because if you delay something for 7-8 years, if you're an innocent person, it's hurting you because you're languishing in jail, whereas the trial is continuing. And if you're a guilty person, you're benefiting because you're saying by the time somebody catches up, the law catches up with me, अरे क्या पता 7-8 साल में कुछ भी हो सकता है. Witnesses will go, evidence will be buried.
No, you're right. So I think one of the primary things, in addition to what Mr. Madhavan and you were saying about, for example, appointment of more judges, filling up of vacancies, which is of course a peremptory thing that we do need to. And frankly, recently we've been doing a decent job of filling up the appointments as and when they happen, which is something quite speedy in comparison to earlier times. However, what I do think is important is we must set time limits. I think we need to set time limits to arguments. We do need to set time limits to adjournments. Incidentally, in law, there is a provision is you can't get more than X number of adjournments. But all said and done, adjournments are done. Now, for example, just take a separate system. Let's take UK for a moment. You have a trial set in, it happens. It happens in a couple of days, and then ultimately dates are fixed. They happen on those days. So we must really stop taking this as a matter of practice, whether as judges, whether as lawyers, to say, I can take time when I want to. And time limitation also, by the way, which you were speaking about, is an essential component. The provisions are there, accepting and unless we really go into the past to an extent that we can, continuing offenses, for example, that's a different matter. It ultimately, you can't have a limitation for that. But where you can have a limitation, excepting for serious offenses, heinous offenses, economic offenses, whatever they might be in that category, which we can classify, we really have to put a time stop to it. We can't let the system go on. The witnesses are not available. The evidence is not available. Nothing happens. I personally have seen so many trials and appeals coming out of those happening where nothing is available. So ultimately, even if assuming it was a good case once upon a time, it's just not going to translate itself. So if we can do that, it is good. However, again, a problem that I will park on the last side to say there are serious offenses which cannot in any manner be put in the same fold and said time bar won't happen. What if there is a scam, which there have been several scams in the country? They've been.
But you can always say there are exceptional circumstances, right? It can be an overall principle, and you can say in exceptional circumstances XYZ happens.
No, you're absolutely right. I'm just saying, for example, 2G. I'm just saying for a moment. So these kind of cases obviously will come on a separate periphery. But having said that, time limitation, a time for trial to be disposed of, bail to be given on certain eventualities. Again, exceptional circumstances can always be classified and
Yeah.
to even left to the discretion of the court.
All right. Thank you so much, Mr. Madhavan. Pinky Anand, thank you so much for being with us.
Thank you.
Right, let's now turn our attention to a really important development that happened this week, which was the Supreme Court verdict, which came out on December the 11th on the Union government's 2019 move to add Article 320 of the Constitution. Now, just recap in case you've forgotten that. What did they say in 2019? The abrogation ended the special status conferred to the erstwhile state of Jammu and Kashmir. The center then also moved to reorganize Jammu and Kashmir into two union territories, Jammu and Kashmir and Ladakh, and left open the possibility that at some point Jammu and Kashmir could become a state once again. And what did the Supreme Court rule this week? Well, the court essentially said that the constitutional order that revoked Article 370 was valid. A 5-judge bench, constitutional bench of the Supreme Court, presided over by the Chief Justice of India, D.Y. Chandrachud, had reserved its verdict on as many as 23 petitions on the matter on September the 5th. But essentially, there were 3 judgments, but they were fairly unanimous on the net outcome. And they said Jammu and Kashmir had no internal sovereignty after accession to India. There was no prima facie case that the president's orders in 2019 were in bad faith or were an extraneous exercise of power. And the Supreme Court also went on to say that Article 370 was essentially just a temporary provision. It did, however, that the reorganization of the erstwhile state into union territories was a temporary move, and therefore it did direct the center for the restoration of Jammu and Kashmir statehood at some point and for legislative assembly elections to be held by September 2024. And there were other suggestions made. Justice S.K. Kaul, for example, recommending the setting up of a Truth and Reconciliation Commission to try and heal wounds in Jammu and Kashmir, and also talking about the human rights situation in Jammu and Kashmir. And also he did talk about the Pandit exodus from Kashmir in 89 and 90. So that essentially is what the Supreme Court said. In India, I think it was around expected lines, not too much reaction to it. In Jammu and Kashmir or in other parts of the country, it was all fairly quiet. So what we're going to discuss on this episode of India Story is really what the international dimension of that has been, what the international reaction has been, because very interestingly, there's been next to no international reaction. Of course, Pakistan did make a bit of a noise about it, but you would expect that. And China, the other usual suspect, made a little bit of a noise about that, but you would expect it. But we haven't heard too much from the rest of the world. Why? And what does that mean for the international dimensions of Jammu and Kashmir? Well, let's now try and take a slightly broader, more strategic view of what the developments mean. Article 370 clearly is history. What does this mean for what happens in Kashmir going forward? And also, what has been the international reaction and the international repercussion? Should we now assume that when it comes to Jammu and Kashmir, other than Pakistan maybe making a few noises here and there, it's pretty much a settled issue now. For more on some of those issues, great pleasure to be joined by Professor Raja Mohan, one of the country's top strategic thinkers, columnists at the Indian Express. Raja, thank you so much for being with us. I think over the decades spent so much time discussing Kashmir and the international repercussions and the rest of it. Pretty much now the Supreme Court has come out and said, look, there was no internal sovereignty after 1947. The question is over. Article 370 is gone. Jammu and Kashmir is an integral part of the country. Yes, you'll have to have elections at some point. The world seems to have pretty much gone along with that, right? Or is there any dissenting notes you've heard from outside other than Pakistan?
No, both Pakistan and China in different ways. Of course, Pakistan, the foreign minister himself held a conference, basically, trashing the judgment. And it's quite amusing to hear from him to say Indian courts have become political in a country where the judiciary has long been the handmaiden of the army. But nevertheless, the Pakistanis made it quite clear they're not going to accept it. Even more interesting is the fact that Pakistanis always used to dismiss Article 370 as a joke, saying that, look, this is all, India's, optics, and really there's no substance. So, but the moment since last August 2019, they've taken this, oh my God, why is India dropping this? So in many ways, for them, the multiple contradictions in their position, but nevertheless, they did react predictably. The second reaction is from China. China made it quite clear that they will not accept Ladakh conversion as a union territory, and at the western border, this is exactly what their spokesman said, not the minister, saying that this belongs to China. So the two disputants to the territory, after all, we've had both of them always, Pakistan and China. Both of them have taken predictable negative reactions. Then I think it looks
just to understand that a little further. Look,
yeah.
Let's face it, when Jammu and Kashmir, the issue first flared up, and it went to the United Nations, for example, 1947, 1948, wasn't just China and Pakistan who used to make noises about Jammu and Kashmir. It was also the West, America, it was Britain, it was a number of other countries who were coming and saying, oh, this issue has to be used. America has used that issue to put pressure on India for a long period of time. The rest of the world now, when it comes to Jammu and Kashmir, are they pretty much on board with the basic principle it's an integral part of India and that's it? There may be questions and arguments about, oh, you have to have elections and human rights and blah, and blah, but by and large, it's a now settled principle that, okay, it's an integral part of India, accepted in the rest of the world with the solitary exceptions of Pakistan and China right now. And we'll come to those later.
Yeah, not so fast, Vikram. I mean, you had the Pakistanis and Turks, I'm sure, obviously got the OIC, the Organization of Islamic Cooperation, to issue a statement that again was predictable because Pakistan has always sought to use the OIC to make statements on Kashmir, and I think that too they got done. I think the rest of the world, they will go by what is practical. I mean, just because our Supreme Court has decided Kashmir is an integral part of India, they're not going to automatically take that position, because historically, if there is a problem between two countries, they're not going to simply say, look, this is really, we're going to tilt to one side. Barring a handful of very close friends of India, I mean, nobody else says it's, that there's no dispute. That there is a dispute between India and Pakistan. Even to some extent, India itself, when it's willing to negotiate with Pakistan, says there is a problem. So I think that problem is not going to disappear. I mean, that problem will disappear only when the rest of the world sees there's not much happening in Kashmir. There is no unrest. There is no insurgency. There is no that there is peace and prosperity in Kashmir. Then people will get used to that new situation. But if tomorrow there's a fresh insurgency, there are more conflicts within and around Kashmir, the rest of the world will say, look, you guys sit down, sort it out, which is what the current US position is. We can talk in detail, for example.
So specifically what the Supreme Court has also said, that have elections by September 2024. The fact that the statehood is restored and elections are held and it's seen to be representative and free and fair elections, would that again be an important step in taking this forward with the rest of the world?
No, absolutely. There's no question. I think the key is, one is the legality, right? Each country is the question of sovereignty, how it is defined, etc. The second is the politics of it. Finally, a state's sovereignty is reflected in its effective governance of the territory. And the problem that we've had in Kashmir in different ways has been the sense that that political compact between Indian state and the Kashmiri people was in a crisis. So constructing that compact, a political compact, which is critical for the rest of the world to see that, look, there is no problem here, things are going well, and if other countries start coming, investing here, then automatically the issue gets off the table. But I think for India, we need to get that political compact right, of making sure the Kashmiris feel they're part of this country, and that they have no reason to create all kinds of issues for themselves and for the rest of the country.
All right. Let's now turn to Pakistan and China. Now, when it comes to Pakistan Pakistan's position when it comes to being able to influence anything in whether it's in India or in Jammu and Kashmir or the rest of the world is sharply diminished. Pakistan itself has become a much weaker state. The economy is in a mess. They're domestically in a mess. They're not really having the capacity to even keep the insurgency running or the terrorism running in Kashmir like they once could. So is there that perhaps realization in Pakistan that we don't really have the ability to keep this on the boil to the extent that we once, or to the same extent that we once used to?
I think the problem for Pakistan is this: having thrown so much, good money at it for so long, that the capacity to walk back from a declared position is very hard. For example, we came very close. If you remember, you covered Musharraf Manmohan Singh period. You had back channel negotiations. We had more recently, again, there were conversations between the two sides. The idea that you can settle as is where is basis, that idea has always run through the bilateral discourse. But the politics of Pakistan, at this point at least, just seem, it is difficult for them, I think, their political class to accept it, nor the political class has the courage to say, look, time has come to make a new beginning. I don't know if you saw last few days, Nawaz Sharif, who's just come back to Pakistan after a long exile, said, look, Pakistan should have good relations with its neighbors, with India, with Afghanistan. But the logic of that means at least taking the Kashmir issue off the table, stopping terrorism across the border. Now, implications of what he's saying is clear, but does he have the capacity to actually implement that is the question. And I think this is where the temptation to internationalize will be there. We saw in 2019 when Pakistan went crazy with the help of China, tried to draw the Security Council into it. Luckily for us, the French and the Americans helped us a lot. So this time, of course, there is no such effort, which clearly reflects what you said. Pakistan is much weaker today.
Yeah,
it's really in a bad position. To the ability, I think India's improved relations with the US, as well as India's improved relationship with the Gulf countries, have actually removed some of the external props for Pakistan's Kashmir policy. So I would say beyond China and Turkey, I don't see much external support for it, but I think that's why it's important for us to consolidate, to move forward within Kashmir.
So let's set Turkey aside for a minute. China, of course, is, as with everything when it comes to India or Indian foreign policy, China is, of course, the dragon in the room, if you like. So China, would it like to turn the heat up on this, or is it just another one of those things that China will keep on doing to keep India off edge, the provocations that keep happening? So do it as low-level harassment of India as opposed to trying to really up.
See, of course, the difference between China and Pakistan, because Chinese state is a more classical type of state. It's not, they're not doing jihadi stuff in India. But they see clearly they apply military pressure, which is more classical forms of coercion. The Chinese, I think, quite just as the balance of power between India and Pakistan has changed in favor of India, the balance of power between India and China is today tilted towards China. China is much bigger. They're much stronger military, they're much stronger defense production. And that is the result of this change in the balance of power that we've seen the Chinese try and nibble at our territory. You remember there have been at least 4 major crises in the last decade, 2013, 2014, 2017, 2020. So as China builds up its military capability on the border, they are mounting relentless pressure on India. And today, if after Galwan, today we have 60,000 troops at 17,000 feet. They're enduring a 4th winter. So the pressure is already on us to be able to defend, not just in Ladakh, which is part of Kashmir, but all across the 3,500 kilometer border, where there are multiple points at which China can take the initiative. So China's challenge will remain in both militarily, diplomatically, because China also uses Pakistan.
All right.
That their advantage is they can keep using Pakistan to do nasty stuff on this side while they keep up the military pressure on the other side.
All right, Raja, we'll have to see how it all pans out, but interesting developments, and also actually interesting to see that there's been relative silence in most of the world, which means seems to be heading in a particular direction. Thank you so much for joining us on the international repercussions and international implications of that Supreme Court verdict on Article 370. Thanks so much for talking to us. All right, let's move now to another one of our regular segments on the India story. What is the global press saying about India this week? Here's a quick wrap-up of some of the big stories.
The BBC is restructuring its operations in India to comply with the country's foreign investment rules. As per the BBC, on the 13th of December 2023, 4 of its employees will leave the corporation to form a wholly Indian-owned company to be called Collective Newsroom, which will run the BBC's 6 Indian language services: Gujarati, Hindi, Marathi, Punjabi, Tamil and Telugu. The public service broadcaster said that the restructuring follows an investigation earlier this year during which the BBC's India offices were searched by tax authorities on charges of allegedly breaching foreign direct investment rules. US President Joe Biden will not travel to India next month. Nikki Asia has confirmed this, quoting a senior US official. Biden had been invited by Prime Minister Narendra Modi to be the chief guest of the Republic Day parade on January 26th. There were also talks of holding a Quad summit the following day in New Delhi with leaders of Japan and Australia. Mukesh Ambani's Reliance Industries and US giant Walt Disney are reportedly discussing a plan to hold next stage talks about their India media business merger in London next week, Reuters said this week, quoting sources. Disney and Reliance are planning to merge their India businesses by forming a joint venture company in which Ambani's media unit would hold a majority stake. A possible merger would create one of India's biggest entertainment empires, setting it in competition with major TV players like Zee Entertainment and Sony, and streaming giants Netflix and Amazon, as per Reuters.
And that's it on this episode of the India Story. We'll be back again next week with all the big headlines out of India and the top experts to help you understand what's happening in the fastest growing economy in the world. Bye for now.